In 1898, the state of Alabama earned 73% of its entire annual revenue from one source. Not cotton, not taxes. People. The state arrested them, convicted them, and leased their labor to private corporations, companies you still know by name. The charge, in most cases, was vagrancy, standing in public without proof of employment. The sentence was hard labor. The profit went to the state. And all of it was legal, because the amendment that abolished slavery left one exception inside the sentence. I found this while tracking people who vanished from the record, men who appeared in one decade and disappeared into prison ledgers in the next. The same pattern kept surfacing in Alabama, Georgia, Mississippi, Tennessee. Men arrested on charges that had no victim, sentenced to terms that had no proportion, leased to companies whose names I recognized. One of those names would eventually become U.S. Steel. What follows is not rumor. It comes from state prison archives, corporate ledgers, congressional testimony, and one Pulitzer Prize-winning investigation that traced a single man through the system. This is not theory. This is bookkeeping. The official story is straightforward. The 13th Amendment, ratified December 6, 1865, abolished slavery. The full text is one sentence long, and in the middle of that sentence, between two commas, is the exception clause that built what came next. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States. Except as a punishment for crime. The amendment abolished slavery, but it preserved forced labor as punishment after conviction. And if forced labor was still legal after conviction, all a state had to do was create crimes broad enough to manufacture convicts. That is exactly what the Black Codes did, within months of emancipation. Mississippi, November 1865. The Vagrancy Act. Under this law, unemployed freedmen could be arrested, fined, and hired out to whoever would cover the debt. If you could not pay, the sheriff decided who you worked for. The law specified preference to the former employer. In many cases, that was the former slaveholder. But here is what the conspiracy theory gets wrong. People tell this story as if it were a secret, a hidden plan by a shadowy network. I spent weeks verifying that framing. It collapses completely. This was not covert. It was statutory. The laws were printed in newspapers. The lease contracts were public records. The revenue appeared in state budgets as a line item. The annual reports of the Alabama Board of Inspectors of Convicts are archived and available. The real story is more unsettling than any conspiracy, because it did not need to hide. It was legal, it was profitable, and it was documented with the precision of an accounting firm. And this is where punishment stopped being the reason, and profit became the point. States discovered that convicts were not a burden. They were an asset. Instead of building expensive prisons, you could lease human beings to private companies. Coal mines, railroads, turpentine farms, brick factories, cotton plantations. And the company would pay the state per head. The company got labor at a fraction of free market wages. The state got revenue without raising taxes. The convict got nothing. The economics were explicit. In 1883, the Pratt mines in Alabama, operated by Tennessee Coal, Iron, and Railroad Company, recorded that convict labor cost 6 to 7 cents per ton of coal mined. Free labor cost 50 cents per ton. That is not a discount. That is a business model built on captive bodies. And the supply was engineered. Mississippi passed what historians call the Pig Law in 1876. It redefined grand larceny, the theft of any hog, pig, cow, calf, yearling, sheep, lamb, goat, or kid of the value of $1 or more, grand larceny. Punishable by up to 5 years in the state penitentiary. $1. 5 years. The law was enforced almost exclusively against black men. The prison population surged. And once you see the revenue, the arrests stop looking random. I want to put a name to this. Not a statistic. A person. Green Cottenham was born around 1885 in Shelby County, Alabama. His parents were formerly enslaved. On March 30th, 1908, 43 years after the 13th Amendment, he was arrested. The charge? Vagrancy. He had no victim. He had committed no act of violence. He was standing in a place, at a time, without paperwork that satisfied a county sheriff. He appeared before a judge. He was convicted. He could not pay the fines and court costs, which were added to his sentence by design. The county leased him to Tennessee Coal, Iron, and Railroad Company, TCI, a subsidiary of United States Steel Corporation, the largest corporation in the world at that time. Green Cottenham was sent to Slope No. 12 at the Pratt mines near Birmingham. He was required to load a daily quota of coal under threat of whipping. At night, he was locked in a wooden barracks, chained at the doors. The mine was dark, unventilated, and saturated with coal dust and tuberculosis. He died inside the mine. A few months after his arrest, the cause recorded in the company ledger? Tuberculosis. Douglas Blackman, the journalist who traced Cottenham's life through court records and mine ledgers, won the Pulitzer Prize for the book that carries his name, Slavery by Another Name. Blackman wrote that what haunted him most was not the violence. It was the silence. The absence of Cottenham's voice from every record. He exists only in the paperwork of the people who used him. And he was not exceptional. He was the template. And this is where the records disappear. Death rates in the convict lease camps were not a secret either. They were measured. In 1873, according to state prison board records, 25% of all black leased convicts in certain systems died within a single year. At Tennessee's Lone Rock Stockade, the annual mortality rate ran close to 10%. Tuberculosis, typhoid, dysentery, beatings, mine collapses. In the worst railroad construction camps, a large share of workers did not survive their sentence. The phrase that defined the system was not coined by historians. It was used by the operators themselves, the lessees, the men who ran the camps. One dies, get another. That was the business calculation. The state provided replacements. The company absorbed no liability. There was no Workers' Compensation Act. There was no inspection regime that could shut a mine down. If a convict died, the company reported the death and requested another body. The state supplied one, usually within days. The system didn't need to hide its mortality because the dead had no advocates. no family withstanding to sue, no union, no press coverage, no one counting. But then I found something else. Someone did count. And they did more than count. They loaded rifles. In 1891, coal mine owners in Anderson County, Tennessee, began replacing free miners, men who earned wages, who fed families, with leased convicts. The convicts were cheaper. They could not strike. They could not negotiate. They could not quit. The free miners understood what this meant. Not just unemployment, the end of free labor in the coal fields. On the night of July 14, 1891, 300 armed miners marched on the convict stockade at Briceville. They broke the stockade open. They put the convicts on a train to Knoxville. They gave some of them civilian clothes and food. Then they burned the stockade to the ground. The governor sent the state militia. The miners waited. When the militia left, the miners attacked again and again. For 18 months, armed citizens fought the state of Tennessee over the right to not be replaced by enslaved labor. It was called the Coal Creek War. The miners lost the battles, but they won something larger. The governor who defended convict leasing lost re-election. Tennessee's legislature refused to renew the lease contracts. By 1896, the state had ended the practice. It took an armed revolt by white miners to end convict leasing in one state. White miners, with rifles, fighting a system built on black bodies. In Alabama, the system survived 32 more years. I spent 3 weeks with this material before I could figure out how to present it. Not because the evidence is thin, the opposite. There is so much documented so plainly in sources that are not obscure or contested that the real difficulty is explaining why none of it is common knowledge. The Alabama Board of Inspectors of Convicts published annual reports from 1880 through 1928. Every name, every charge, every company, every death. Open, public, archived. Between 1866 and 1928, according to Douglas Blackman's analysis, an estimated 800,000 people were leased through the system across the South. The companies in those ledgers, TCI, Sloss Sheffield, Georgia, and Alabama Railroad, were not rogue operations. They were shareholders, board members, pillars of the post-war industrial South. The convict lease system was not an aberration of capitalism. It was a feature. Labor at near zero cost, subsidized by the criminal justice system, funded by the taxpayer, and insured by the state. Watch the timeline. Not as isolated events, as an infrastructure being built. 1865, 13th Amendment ratified, loophole included. 1865, Mississippi passes black codes within months. 1866, Alabama begins leasing state convicts to private contractors. 1868, Georgia follows, then Texas, then Louisiana. 1876, Mississippi passes the pig law. $1 theft equals 5 years. 1883, Pratt mines. Convict coal costs 7 cents a ton. Free coal costs 50. 1891, Coal Creek War. Tennessee miners revolt. 1896, Tennessee ends convict leasing. 1898, Alabama earns 73% of state revenue from convict labor. 1907. U.S. Steel acquires TCI, continues using convict labor. 1908. Green cottonum dies in slope number 12. 1928. Alabama becomes the last state to formally abolish convict leasing. 63 years, from amendment to abolition. In between, a labor system indistinguishable from the one it replaced, except for the exception clause in the middle of a constitutional sentence. But the most disturbing part of this timeline is not the beginning. It is the end. Because the end is not 1928. The 13th Amendment was never rewritten. The exception clause, except as a punishment for crime, is still there in 2026. In the Constitution you carry in your pocket, today, nearly 800,000 incarcerated people in the United States perform labor. Some earn pennies per hour. Some earn nothing. The goods and services they produce, furniture, clothing, electronics components, license plates, food, prison maintenance, generate more than $11 billion annually, according to ACLU estimates. The exception clause has never been removed. In November 2022, voters in 5 states considered ballot measures to remove slavery exception language from their state constitutions. Tennessee, Vermont, Alabama, Louisiana, and Oregon. 4 passed. Louisiana's failed. 59% voted to keep the exception. The federal Constitution has not been amended. I traced one man, Green Cottonham, from a county jail to a coal mine to a burial record with no headstone. The system that killed him turned poverty into crime, crime into labor, and labor into revenue. It was not hidden. It was budgeted. The corporate lineage that profited from the system did not vanish when the camps did. Convict leasing ended. The system today is not identical to what came before, but the constitutional exception that once made coerced labor legal after conviction was never removed. The form changed, the logic survived, and the clause is still in the middle of the sentence.